Let's break this down now with MS Now Justice and Intelligence reporter Ken Dilanian in Washington. Here in New York, our senior legal reporter Lisa Rubin and former Assistant Manhattan District Attorney Rebecca Roiphe. Also with us, New York Times Chief White House correspondent and MS Now contributor Peter Baker. Ken, assuming the DOJ does appeal, as they've stated they plan to do, how might this proceed?
Well, good morning, Anna. As you said, Judge Cameron Curry ruled that the appointment of Lindsay Halligan as U.S. Attorney violated the Appointments Clause of the Constitution, and that all actions flowing from what the judge called her defective appointment were invalid, including the indictments of Comey and New York Attorney General Letitia James, and those had to be dismissed. Now, there is some defiance inside the Justice Department. We learned last night that after initially removing Lindsay Halligan's name from the signature block of briefs and indictments and legal documents filed by that office in the Eastern District of Virginia, a decision was made to restore that name, Lindsay Halligan's name, as the U.S. Attorney, even despite this ruling. Pam Bondi, the Attorney General, yesterday vowed to appeal this decision. Take a listen.
We'll be taking all available legal action, including an immediate appeal, to hold Letitia James and James Comey accountable for their unlawful conduct.
So there's a long road of litigation ahead, and even if this decision is overturned somehow or the case is indicted again, there are obviously many other motions that James Comey has made to try to invalidate this case, including arguing that this was a vindictive prosecution on it.
Lisa, why would the judge in this case dismiss without prejudice, essentially leaving open the door for these cases to be brought back to life?
Well, I can answer that question pretty squarely with respect to Letitia James. I think the reason you dismiss without prejudice is because there's a clear federal statute that says when a case is dismissed for reasons other than a time. I'm sorry, that's not the case with respect to Letitia James. I'm mistaken for a second. With respect to Letitia James, I think the issue is there is no time bar here. The issue is solely a question of did the person who had the authority bring the instrument? And the answer is no, because this isn't a question of the merits of the case. She is affording them the opportunity to refile if and when a properly appointed U.S. attorney takes that spot. With respect to Comey, that's a little bit dicier, particularly because, Anna, while she is dismissing without prejudice, there's a footnote in the case that essentially says the door is closed. That because Jim Comey faced a statute of limitations and because Lindsay Halligan alone indicted him just days before that statute elapsed, if the indictment was void from the outset, which she finds it was, then the statute of limitations door closes right behind her, and therefore there is nothing to revive or resuscitate. That's a suggestion in this footnote, but as you say, the holding is without prejudice. That has some folks scratching their heads about what the real import of yesterday's decision was for Jim Comey. Jim Comey's lawyers saying that you have to trust the footnote. The Department of Justice obviously may take a different position.
So, Rebecca, I wonder, would Comey's attorneys still try to push forward with those other motions to dismiss, like on vindictive or selective prosecution, as this appeals process plays out, just in case?
My guess is they're going to have them in their arsenal ready to go, but we'll wait and act as if this case has been dismissed while the appeal is pending.
So that doesn't continue, like that this case in all of the courts that have taken issue with it or have taken it up go away.
Right.
Okay. So let's listen to a little bit more from Attorney General Bondi yesterday when she was asked about Halligan.
What happens to U.S. Attorney Halligan now? Will she remain in her position while the appeals process plays out? And does that threaten to upend other cases in the office if you guys don't win on appeal?
It does not. We have made Lindsay Halligan a special U.S. attorney, so she is in court. She can fight in court just like she was, and we believe we will be successful on appeal. And I'll tell you, Lindsay Halligan, I talked to all of our U.S. attorneys, the majority of them around the country, and Lindsay Halligan is an excellent U.S. attorney.
So, Lisa, let's talk about that special U.S. attorney retroactive role, essentially, that the Attorney General gave Lindsay Halligan. Was that addressed at all in this decision? And what does it mean in terms of potential next steps?
Let me read to you, if I can, from the judge's opinion. She's saying that she rejects the Attorney General's attempt to retroactively confer special attorney status on Ms. Halligan, regardless of what the Attorney General intended or could have done when Lindsay Halligan was first appointed. The fact remains that at the time of the indictment, she was not an attorney authorized by law to conduct grand jury proceedings when she secured Ms. James's indictment. This comes from the James opinion. The same is true for Jim Comey. Now, on a going forward basis, can Attorney General Pam Bondi name Lindsay Halligan a special attorney and attempt, therefore, to confer on her most of the powers of a U.S. attorney? She could. Whether that or not will be successful or not remains to be seen, could in fact be litigated again. But at least on a retroactive basis, this judge finding you can't sort of shore it up after the fact. You can't put belts and suspenders around what was a defective appointment.
And from the beginning, it stood out that Lindsay Halligan was the only prosecutor to sign the indictment. That's important here because let me read from the judge's opinion. This case presents the unique, if not unprecedented, situation where an unconstitutionally appointed prosecutor exercising power she did not lawfully possess acted alone in conducting a grand jury proceeding and securing an indictment. Rebecca, just how much of an unforced error was this?
It was an unforced error. And, you know, as I'm listening to you both so intelligently take apart this opinion, one important thing to note is that it sounds almost like this is a technicality, that in a way that this indictment was dismissed on a technicality, but it really wasn't, because all of these appointments rules in the Constitution and in the statutes are designed to ensure that the person who has that position is both experienced and understands the norms and traditions of the office, and that's what protects and ensures impartial prosecution. So it isn't, while it's unrelated in some ways to the vindictive prosecution claim, it's not as unrelated as it first seems, because having somebody qualified in that role should help us be assured that the indictments that result from that office are valid.
Well, we all recall that there was that memo, that declination memo that suggested the people within that office, the career prosecutors, did not believe there was a strong enough case to try to bring charges. Peter, what does this mean now for the president's strategy to just install loyalists in these U.S. attorney offices? Will it now force them to go through the Senate confirmation process?
Well, obviously, there are more than one U.S. attorney around the country right now who have been installed in this fashion. And it, of course, does remind us that, yeah, the Senate is supposed to have an advice and consent role here. And the president, for his first term and now in his second term, has stretched the boundaries of that in all sorts of ways, in all sorts of parts of government where he has installed people who have served for months on end without any kind of Senate scrutiny, even though they were in jobs where they're supposed to be. So, yeah, obviously, they're going to have to take that into consideration as they go forward. I would like to just back up again as well and say that we're debating here, you know, what the law is and the technicalities and the rules and the procedures, all of which are very important. But the broad story here, of course, is a president who is directing his Department of Justice to go after his enemies. And I just want to emphasize again how incredibly unusual that is, how unique that is in our modern times, that we've now kind of gotten to the point where we're kind of used to this. We sort of assume this is the way it works. It's not the way it normally works. No president since Watergate anyway has, that I know of, publicly, in fact, demanded that the Justice Department prosecute his political enemies. And what the court is doing here is saying you have to follow rules, but there's a broader issue at stake as well.
Yeah, many other administrations have gone through great steps to try to create separation between the White House and the Department of Justice. Ken, I'm curious what you're hearing from your DOJ sources about this moment. Is there a sense of embarrassment, frustration, or maybe elation?
Well, certainly career DOJ officials are embarrassed and frustrated. They've been embarrassed about a lot of things that this administration has done. But to build on Peter's point, not only are they going after Donald Trump's enemies, they're doing it based on thin, or non-existent evidence. And so Pam Bondi and Todd Blanche, who run the Justice Department, are a lot of things, but they're real lawyers and they don't like to lose in court. And there is a kind of a growing sense of unease that we're detecting. Todd Blanche in particular is sort of getting tired of the DOJ being embarrassed in court. He's in a difficult position, though, that they're under an obligation to proceed with these cases. You got another grand jury investigation of Adam Schiff around specious mortgage fraud allegations. And we have reporting that actually they may be investigating the investigators in that case. So it remains to be seen exactly how they will continue pushing these retribution cases even when they are blowing up in their face and they're losing in court. And it's only going to get worse from here. This is a, sort of a technical procedural ruling. If judges have to start ruling on the substance of whether these are vindictive prosecutions or whether they were presented correctly, that could be a whole other can of worms and unpleasant situation for the people leading the Department of Justice on.
I did hear you say yesterday, and it stood with me, that, somebody you had spoken to had called this a great day for the rule of law, noting that the checks and balances perhaps were working through, the outcome here in this case. Peter, you pointed to the fact that there are now at least 4 interim U.S. attorneys who have been disqualified. Plus, we learned DOJ official Ed Martin, as well as housing official Bill Pulte, are under federal investigation for how they've handled mortgage investigations into Trump foes. So here Comey is saying this case was based on incompetence. Makes me ask, is incompetence really what is stifling these signature cases of Trump's retribution campaign?
Well, it's a willingness to go beyond the normal standards of how these things are done, right? The career prosecutors in the U.S. Attorney's Office in the Eastern District of Virginia said there's no case here against Letitia James or Jim Comey, and the president refused to accept that. He forced out the U.S. attorney who refused to press cases that he thought were bogus and put in somebody as personal attorney from the White House who had no prosecutorial experience in order to pursue these cases. That by itself sends a signal about what the merits of these cases, to Ken's point, really are. And I think that it's also worth remembering, by the way, that it was the Trump people who called Judge Cannon's ruling last year when she said that Jack Smith, the special counsel, had been inappropriately appointed. They call that total exoneration of the president. And now they're calling this ruling, in which they're saying Lindsay Halligan was improperly appointed. They're calling it a mere technicality and an activist judge who's taking things too far.